Good morning. I'd like to welcome the students from Crossroads Christian School from Henderson. Welcome to the Supreme Court. I'm glad to have you this morning. Our next case is State versus Macon, and we will hear from the appellant.
Good morning. May it please the court, I'm Assistant Appellate Defender Wyatt Orsman, and I represent Mr. Macon, the appellant in this case. I'd like to reserve 7 minutes for rebuttal. And I see that we have some students in attendance today, and I hope that myself and my colleague can show them what a good oral argument hopefully looks like. And if that fails, hopefully we can show them what a good, bad oral argument looks like, what not to do. In Ferretta, the Supreme Court held that the government can't force an unwilling defendant to accept an attorney. Central to the court's decision was its recognition that the Sixth Amendment embodies the founders' respect for individual autonomy and free choice. Defendants are free to accept the assistance of counsel if they want it, and they are free to refuse it if they think they can better represent themselves. When a defendant expresses a desire to represent themselves, Ferretta requires courts to ensure that the defendant knows what he is doing and that his decision is made with eyes open. That translates into a requirement that the waiver of counsel be knowing and intelligent. To ensure that a defendant's waiver meets this constitutional standard, the trial court is required to conduct a thorough inquiry that includes providing the defendant with information the Supreme Court has held indispensable to the defendant's decision. One piece of required information is the allowable range of punishments associated with the charges the defendant is facing. This warning, like all other required warnings, must be rigorously conveyed. These requirements, a thorough inquiry, a knowing and intelligent waiver, and a warning regarding the allowable range of punishments, are imposed by both the Sixth Amendment and Section 1242, North Carolina's statute designed to protect the right of counsel from uninformed waivers. But here, Mr. Macon was charged with 24 counts of a reportable Class E felony. Under structured sentencing, each count carried a theoretical maximum of 136 months. Multiply that by 24. Quick, can anybody? You get 3,264 months. However, during her colloquy with Mr. Macon, Judge Adams incorrectly told Mr. Macon that each charge was worth 63 months and that the aggregate maximum was 1,512. The trial court misinformed Mr. Macon of both the individual maximum for each charge and the aggregate maximum. Both sentences are off by 115%. The aggregate is off by over a century. Based on this grossly inaccurate sentencing information, Mr. Macon, his decision to waive counsel was not made with eyes open, as required by Ferretta. His uninformed waiver wasn't knowing and intelligent, and the trial court's colloquy was fatally deficient under both the Sixth Amendment and 1242. The state argues that neither the Sixth Amendment nor Section 1242 are violated because there's no meaningful difference between a 1,500-month sentence and a 1,600-month sentence. They both amount to a life sentence, according to the state. But that's not what the Sixth Amendment or what 1242 demand.
You keep mentioning the Sixth Amendment, but Your client's not making a Sixth Amendment argument, right?
I'm sorry.
Your client's not making a Sixth Amendment argument, right?
He absolutely is making a Sixth Amendment argument.
But that's not an issue that, I mean, did your client assert that Sixth Amendment argument in the Court of Appeals? Is that a basis for the PDR here? I didn't see that being part of this case.
Yes, he argued it in the Court of Appeals in his brief. He argued that the trial court's colloquy was a dual violation of both the Sixth Amendment and 1242. Those are the language I used. I set out in the standard of review, the review for statutory errors as well as for constitutional errors. I mentioned in my rule section of my brief, I mix in rules regarding 1242 and rules coming from the Supreme Court. I believe it was adequately briefed. That's my position. I believe it's also intertwined with the issue presented in the PDR that the Sixth Amendment argument and the 1242 argument are closely intertwined. They use the same terminology. They use the same language because they're getting at the same thing. I cite the LeBron case in my memorandum of additional authority. This case is exactly like that one. I could have used better, clearer language in my issue presented, but the facts that relate to both issues, the facts that relate to both issues are the same, and the law, right, is the analysis is the same. I think it's exactly like the LeBron case, and I think if you disagree with my position that the Sixth Amendment argument, I either defaulted in the Court of Appeals or in my PDR, I filed a conditional petition for writ of certiorari that asked this court to grant. Mr. Macon should not suffer for my sloppy drafting. This court has.
I'm not sure that your performance in this case was in any way ineffective by not raising that. I mean, the Sixth Amendment argument is one that I don't think your client can win, but I do think it's fair to say that perhaps the statute is more protective than the Sixth Amendment, has a stricter requirement about what you need to tell the defendant during this colloquy, because it seems to me under federal precedent about the Sixth Amendment, this was certainly enough. And so we're really looking at, did you comply with the statute or not, which is why I thought you were focused on that. And then the real question is, if there was a violation of the statute, are we in the structural error realm that the Sixth Amendment would be, or are we in the statutory violation, reasonable possibility, harmless error analysis? Mm-hmm. But you're saying really you want to argue that this was a Sixth Amendment violation, that the Supreme Court of the United States would say this violated the Sixth Amendment.
Yes. To be clear, I'm arguing both, that it's a violation of the Sixth Amendment and 1242, that they run parallel. It's my reading of the case law is they rise and fall together. I think my reading of federal case law is they are equally demanding in what's required for the trial court to do to ensure that the defendant's waiver is knowing and intelligent.
Right, but the thing about a knowing and intelligent waiver is that you can find from the circumstances it was knowing intelligent, even if you couldn't check every box in like a statutory list of, if you do these things, we know it'll be knowing and intelligent. And I think the problem that your client has is what you just indicated, that once you get to a certain amount of time, it doesn't matter how much more time you add on to a sentence, because you will die in prison. Nobody lives that long. And I think at that point you understand, if you're being told you'll spend 125 years in prison, that if actually you would be there for 200 years, it wouldn't matter. 272, I guess, in this case, right? That wouldn't matter, because you'll never get out of prison. And that, I think, is why it wouldn't be a Sixth Amendment violation. So aren't we really needing to focus on, does the statute somehow provide a stricter requirement that you have to get the math right on the maximum possible sentence.
Well, I fundamentally disagree that that advising a defendant by telling him that his sentence, giving him a sentence that's off by 146 years doesn't matter.
Well, but
right.
I mean, let me show you. I know that we're getting into.
We have Patterson that says these must be rigorously conveyed. You referenced the whole record test, but there's a circuit split on that, right? I mean, if this court wants to weigh in and choose sides on that, it can. But like you should know that there's a circuit split on that, and it hasn't been endorsed by the Supreme Court.
But what I'm getting at is maybe we don't need to worry about all that because. So let me give you an extreme hypothetical to show why I don't know if your position holds up in every scenario. So imagine if that it was someone that committed a lot of crimes. So the maximum possible sentence is over 10,000 years in prison. And there was a calculation error, so you were off by several hundred years. It would be such a tiny percent of a mistake that it would be hard to plausibly say, you're off by 0.01%, let's say. Maybe it's 100,000 years. How could that possibly make any difference? And so I think you can see the problem is if we're having to draw a line, then it seems like the logical line would be if the length of time is so long that you'll never get out of prison.
Okay.
Then
so that gets to the question of prejudice, not error.
Well, but if it's the range of possible punishments, the upper range is as long as you can possibly be alive. We can't sentence dead people to spend more time in prison. They're dead. So that would be the argument, is if what you're being told is you will spend the rest of your life in prison, then it just doesn't matter how long the technical sentence would be, it's the rest of your life. What's wrong with that?
Right. But
and that avoids the prejudice question. That means there's no error because the trial court
absolutely not
followed the statute.
Not. If you do not fully inform a defendant of the allowable range of punishments, it's error.
But
that's what the statute says.
Yes, and
you have to fully inform him of the allowable range of punishments.
But what I'm trying to get you to understand,
the analysis of whether.
Can you see though?
Excuse me, counsel. Please don't talk over a justice.
Excuse me.
I was talking over you, to be fair, but this is my question that I want to make sure you understand my question. What I'm getting at is that if we understand that the range of possible punishments, that the upper range that you could ever sentence someone to, just because of the reality that we're living people, and once we die, it doesn't matter how much more time we had on our sentence, that the maximum possible range can only go up to as long as you will be alive. And that once the judge has told a criminal defendant, that's how long the maximum is, that you will go to prison and you will never come out, you will die in prison, that it doesn't matter anymore if you got the numbers right. And if we think that that is what the statute means, then there's no error in this case, because that is what, in this case, the trial court told your client, which is that it's so long you won't get out. So that's what I'm looking for, is there's something wrong about that interpretation of range of possible punishments.
I apologize again for speaking over you. That was an example of bad oral arguing. I think the main problem with that position is that it is consistent with the statutory language. The plain statutory language requires the defendant to be informed of the range of punishments. Telling him something that isn't correct is an error. You used the words, it's off by a little bit. It's a mistake. It's an error. It's an error. Your question about whether it would have made a difference, whether it would have impacted Mr. Macon's decision, that goes to prejudice.
Well, what I was getting at, though, is if you could make a calculation error, but that it's not, you still complied with the statute, even though you made an error in calculating the sentence, because the statute doesn't say you must tell the defendant the precise possible maximum. It says that the judge needs to be satisfied the defendant understands the range of possible punishments. And if the range is you'll never get out of prison, it'll be as long as you live. It really doesn't matter if there are mathematical errors, because the defendant understands that that's the maximum.
I think that would be a radical rewriting of the statute. It says, inform him of the allowable range of punishments. I don't, well, I shouldn't speak for the legislature, but you would be reading into the statute, you have to tell them accurate information, or you have to tell them precise information, right? That's right. That's the one, right? I don't think it's a reasonable interpretation to say you can fudge.
Are you conceding that there is no prejudice?
I'm not sure I understand your question.
So you're saying that it's error, and you're saying that the fact that the trial court was off goes to the question of prejudice. So are you conceding that where there's an error, like in this case, but functionally it's a life sentence either way, that there's no prejudice?
No, I'm arguing that under the Sixth Amendment, which we're not sure about, it's structural error. So
What about under the statute,
though? That it's automatically prejudicial error.
What practical difference could it make to the defendant? That is the mistake. What practical difference could it make to his thinking, his analysis?
We don't know.
Well, can you help me imagine?
Well, that's why we don't engage in prejudice analysis for violations of 1242. Right? That's exactly what this court did in McHower, Bullock, Pruitt, Dunlap, and more.
Suppose we were to say that a prejudice analysis applies, then how would we approach it in your view?
Then I believe it would be impossible for Mr. Finner and any other defendant to prove prejudice. Virtually impossible.
So I've been trying to understand what the Court of Appeals said in State v. Gentry, and I may be missing it, but I don't think that the analysis there was really about prejudice. What the court was, as I understood what the court there was saying, was that the statute requires that the trial judge be satisfied that the defendant comprehends the nature of the charges and proceedings and the range of permissible punishments. So the question here is, in light of the mistake that was made about the range of possible punishments, can the trial court be satisfied that the defendant comprehended the range? So it's not prejudice might come in if a defendant is or you know, it might impact the outcome of the trial if he's, you know, not given an attorney, or if he wants a jury trial and is not given. We say those are structural errors. We don't have to show prejudice. It seems to me here this is not really about prejudice. It's about whether or not the trial court could, in these circumstances, determine that could the trial judge be satisfied that the defendant understood the range. And that doesn't seem to me to be a prejudice question. It's just an analysis of whether, when the trial court makes a mistake about the number of years, can they be satisfied? And so in Gentry, it seems like what the court was saying was, well, if what the defendant seemed to understand was that he would spend the rest of his life in prison, I am satisfied that he understands the possible range, even though I got the numbers wrong. Why is that a wrong analysis? Of Gentry.
When we're dealing with a prejudice analysis, right, the type of error that occurs informs the type of error analysis that that the court is supposed to conduct. Here, right, the relevant decision maker that we're looking at is Mr. Macon, right? Was the correct information, would it have impacted his decision? And that's exactly what Gentry looks at. It says, would Mr. Gentry have made a different decision had he been correctly informed? Right? That is prejudice analysis. Would he have made a different decision? would this have materially affected his decision? I guess I see that as prejudice analysis. But I mean, to respond to, I mean, I think it's also difficult to say that the trial court could be satisfied, right? The burden is on the trial court to be satisfied that the defendant knew the permissible range of punishments. How could she have been satisfied when she was off by 146 years?
Does it impact your analysis at all that 4 months earlier, the defendant had been properly instructed about the maximum sentence, and the defendant indicated to the judge that the defendant understood, saying, "I'm fully aware of that"?
Yeah, I think that's a great example of how this case comes together, right? The trial court that conducts the colloquy has to be satisfied that the defendant understands the permissible range of punishments. The state, in its brief, I think, as a fallback position, asks this court to apply the whole record test, right? The colloquy is deficient, so let's fan out. Let's see if there's other evidence in the record that could show that his waiver was knowing and intelligent. State cites cases from 8 different circuits that use the whole record test. Over half the country. The state can't point to a single case from over half the country where the defendant was given conflicting sentencing information from 2 different judges, and the defendant's waiver was still found to be knowing and intelligent. 8 circuits. Can't find a single case where a defendant knowingly waived his right to counsel despite hearing 2 different sentencing pieces of information.
Did any of those cases involve a scenario where both of the sentences were longer than any human being has ever lived?
I do not recall.
I don't think they were, and that seems to me to be what makes this case in Fenner something else, which is we really need to figure out is there some sentencing range where it's all the same at some point, because just people don't live that long.
Well, that's true. One other point I want to make about Gentry is the court's analysis focused on whether the correct information would have had an impact on the defendant's decision. But in Loeffler, the Supreme Court said appellate judges can't read defendants' minds. Any discrepancy in the amount that the defendant is told or informed has constitutional significance. If it has constitutional significance, it has statutory significance. On the issue of prejudice, we know from 40 years of precedent from this case that violations of 1242 are automatically prejudicial error. This court has reached that conclusion 5 out of 5 times. The state mentions or argues in its brief that error per se only applies to a complete failure to conduct the colloquy. Only if one didn't happen at all. But this court's case law in Dunlap and Bullock, for those 2 cases, disprove that argument. In Bullock and Dunlop, there were partial colloquies. This court still found an error, still found a violation, and it still didn't review the error for prejudice. The state also makes the argument that that a violation of 1242 can't be automatically prejudicial error because this court has never uttered the words error per se in any of those statutes. But we know from Singleton that magic words or talismanic incantations don't turn the law. It's substance that counts. In every single case this court has found a violation of 1242, it's ordered a new trial. In every single case this court has found a violation, it has not uttered a single word about prejudice. It has not mentioned 1443. It has not mentioned its standard. It has not applied that standard. It has not discussed whether the defendant satisfied his burden under that standard. It is the substance of these cases that matters. And that substance is that this court treats violations of 1242 as automatically requiring a new trial. I've run over the time that I wanted to spend. If there are any other questions, I'd be happy to answer them.
Thank you, counsel.
Again, I apologize, Justice Dietz.
We'll hear from the appellee.
Good morning, Mr. Chief Justice, Associate Justices, and may it please the court. My name is Caden Hayes. I'm with the North Carolina Department of Justice, and I'm representing the state in this matter. Your Honors, as Justice Dietz pointed out at the very beginning, there is a preserved statutory claim that was contained in the PDR that was addressed at the Court of Appeals and is now been fully discussed, and we're now sitting at argument for. There is also an unpreserved Sixth Amendment claim that we are now talking about for the first time here. There is, as you point out, Justice Dietz, it's beyond the scope of what we're talking about. I will address both the Constitution and statutory issues, but I want to make that clear at the outset. I also want to make clear as we're talking about the statutory prejudice and this court's precedents. This court in State v. Dunlap, after concluding that the trial court had conducted an insufficient colloquy, before ordering a new trial said, and I quote, "Had an appropriate inquiry been made, the defendant might well have concluded that despite his differences with court-appointed counsel, it would be in his best interest to continue to accept Mr. Snow's active representation, as he did at the end of the trial, after being totally frustrated in his efforts." That is a prejudice analysis. That is exactly what the state has been advocating for in its briefing if we're talking about prejudice. So the idea that this court has never applied a prejudice analysis in this context is not correct. It did so in State v. Dunlap. Now, with that said, I do want to circle back to this statutory discussion. Section 15A-1242 requires the trial court to conduct a thorough inquiry and be satisfied, among other things, that the defendant understands the range of permissible punishments. This case involved a number of different charges with a theoretical maximum sentence that exceeded 3,000 months. Yes, the trial court did miscalculate that and sentence or inform the defendant of only 1,500 months. But as Justice Dietz pointed out, no human being has ever lived to either of those values. The important information that the defendant needed to know under statute was that he would die in prison, or he could die in prison. That was the maximum amount of time the trial court was authorized to impose. So, if we take this logic and we apply it to the statute, or we apply it to the situation here, the trial court correctly advised the defendant that he was facing life imprisonment. And the slight miscalculation, to be clear, it was mathematically not a slight miscalculation, but practically speaking, slight miscalculation did not run afoul and vitiate compliance with 15A-1242. Even kind of moving past that, If we get more into the kind of prejudice discussion, typically this court looks at section 1443, that's statutory definition for prejudice, and it provides that a defendant must show for statutory violations a reasonable possibility of a different outcome at the trial upon which the appeal is being taken. Of course, the error in this case, and I think this is a crucial issue that my friend and I disagree on, is what is the error? The error, at most, was this inquiry, was this colloquy. That error, which again the state is not conceding it was error, but that theoretical error does not directly impact the jury's verdict.
So,
Before you go further, sorry. Go ahead. Well, I was going to actually ask you about something Justice Earls had asked, but if we agree that, as Justice Earls was indicating, that Gentry may not have been a prejudice case, but was actually an error case, was the statute complied with or not, do we need to worry about whether or not there's, what the prejudice or harmless test is here, if there is one? Because if there's no error, we really don't need to get into that. And I think your friend pointed out there could be much tougher cases, like one where the trial court said the maximum sentence is 8 years, but actually it was 10 or something like that. So if we read Gentry that way, do we need to address everything I think you're about to tell us?
Certainly not, Your Honor. If there is no error, of course, there is no need to dive into prejudice. And I think Gentry recognized that there are certain types of what we'll call technical miscalculations or technical errors that have no realistic impact upon a defendant's ultimate decision to waive counsel. And Gentry was trying to capture that by putting forth this reasonable likelihood that the defendant would, or in the case would not, waive counsel, but for this erroneous information. Adopting that standard, we do not have to discuss prejudice whatsoever. However, there does seem to be, as my friend points out, this court does consistently say prejudicial error in certain contexts. And I will go through all of the cases that he cites and explain why this court has never actually said error per se or any equivalent if we're talking about, my friend was talking about talismanic language.
but I think I was going to ask pretty much the same question, but in a slightly different way, which is to say, are you arguing to us that under the statute, under 15A 1242, if it turns out that the defendant did not comprehend the nature of the charges against him, that the trial judge could not have been satisfied that the defendant understood the nature of the charges against him and the range of permissible punishments? So assuming that part of the statute is not complied with, that we would then still need to go on and assess whether or not that the outcome of the trial would be different as a result?
So I think
whether or not he was prejudiced by the fact that he didn't understand the nature of the charges against him and the range of possible punishments?
So in short, Your Honor, yes, by logical operation of that statute, an inadequate inquiry, if we're kind of assuming for the purposes of this discussion that happened, doesn't directly impact the jury's verdict or the sentencing that is.
So I'm positing the hypothetical that the judge did not comply with the statute, could not have been satisfied that this defendant understood the range of possible punishments. And you're suggesting that and this is where I don't think it's prejudice. It's a question of whether or not the statute was violated. Because would we be assessing whether he would have still decided he didn't understand the charges or what he might be punished, but he would have decided, if he did understand, to go ahead and represent himself? Or are we deciding if he had represented himself, instead of having counsel, the outcome would have been the same, that he would have still been convicted? Because those are two different questions.
They are two different. Oh, I'm sorry, I didn't want to.
No.
Those are two different questions, but those are two questions that must be answered in order to assess prejudice. 1443 requires that every statutory violation, the defendant must show prejudice, a reasonable possibility of a different outcome at trial. Now, certainly, by and large, having counsel for long periods of time or for the entire trial will probably meet that prejudice standard. But again, we're not talking about the waiver or whether the waiver was valid. We're talking about the thorough inquiry and whether the trial court was satisfied, as you point out, Justice Earle. So if in a world where the trial court ran afoul of 15A 1242, It did so outside the presence of the jury. It did so unrelated to the presentation of evidence. And so there's a threshold thing that must be addressed, which is, would this have changed the defendant's mind? And I think Dunlap presents a really good analysis of that, where we say, yeah, it would have changed his mind, as this court found in Dunlap, and it laid out some of the facts that led to that point. We don't have any of those facts here. The defendant was fully sure that he wished to proceed pro se. He repeatedly uttered it, and he represented himself for the latter portion of the trial. I want to now go through, defendant cites a number of cases and says that this court, if we look at it as a whole, has implicitly created an error per se. Starting first, of course, with Harvin, that relevant portion was just this court quoting the Court of Appeals opinion below. Harvin ultimately dealt with a forfeiture of counsel issue, and so the Court of Appeals discussion on prejudicial error per se, has no bearing upon what this court decides here, and it certainly is not representation of this court's established precedent.
But in Harvin, we didn't ask the question whether or not the outcome would have been different. We said that he did not forfeit his right to counsel, and we remanded for a new trial.
Yes, Your Honor, most definitely, and that's because we're not looking at, was this colloquy, was this inquiry deficient? This court concluded that the decision to strip the defendant of his right to counsel, or more specifically, the defendant's actions, were not sufficiently egregious to warrant that, was error. And so if we undo that error, has there been prejudice? This gets into a more kind of structural analysis, a constitutional analysis that I'm trying to stay away from, because like I mentioned at the top, we have a Sixth Amendment claim that's kind of orbiting, but it's unpreserved, and we have this statutory one. So the issue is, what's the error at most? In this case, it was this potentially deficient colloquy, but that deficient colloquy didn't impact the trial in any way, unless the defendant also would have changed his mind, but for this error that we're kind of talking about. And more to that point, defendant cites Pruitt, which was a case where the trial court failed to conduct any inquiry. Similarly, in Moore, it conducted a deficient-ish, not really any sort of inquiry, and Moore relied upon his defendant's counsel's statements to the court. Under this prejudice analysis, I think it would be hard for a defendant not to show prejudice when there is no inquiry whatsoever. The state is not advocating that is a unique set of error per se. We're saying that it is not hard, and in those cases, the defendant had met his burden by showing there was no inquiry whatsoever. That is different and complies with 1443's kind of general requirements. It complies with Hamer's, complies with Jolly, Malachi, all of this robust case law that says that a statutory error, the defendant must also show prejudice to succeed. And in this case, the defendant has not shown such prejudice. Indeed, in none of his briefing before the Court of Appeals, before this court, has he ever asserted that he would not have waived counsel but for this miscalculation. And while that certainly, in the state's opinion, would not be enough, it is, at the very least, the starting gun before we start talking about, okay, has a sufficient showing been met? I want to pivot now to this Sixth Amendment discussion, just to make sure to cover the bases. To be clear, the defendant did not preserve this discussion at the Court of Appeals, and it was not included in his PDR. Additionally, the Sixth Amendment and the statute, though both implicating a defendant's right to counsel or lack thereof, or ability to self-represent, they are two distinct entities. Section 15A, 1242, is a directive to the trial court to conduct this inquiry, to take these steps. The Sixth Amendment, however, focuses on what the defendant knows at the time he or she is waiving counsel. So it's important we not conflate the two. They're two separate and independent things. So moving past this kind of distinction and addressing the merits notwithstanding the lack of preservation, Sixth Amendment, because we're looking at what the defendant knows, we look at the whole record. We look at everything that we can see. We look at, most notably, a plea hearing that occurred several months prior to trial, where the judge who was presiding that day correctly informed the defendant that he would face a theoretical maximum of 3,264 months. We see that he says, "I'm fully sure," or fully aware, when he's asked that or informed that. So the record reveals defendant made this decision with his eyes open. He knew the possibility that he could spend the rest of his life in prison. And even if we want to go down and say, well, the Sixth Amendment requires such hyper-specificity that one life sentence does not equal another life sentence, he knew of the theoretically correct value, 3,264 months, before he waived counsel. And that's all a Constitution requires. Moving into the kind of prejudice analysis, I know there's a lot of discussion about structural error or lack thereof. The Supreme Court has never stepped in and said this is structural error. Justice Dietz, you point out that this is maybe something that this court would not want to wade into, but I want to address it just briefly for completeness sake. Defendant cites McCaskill and Gideon and its progeny for the idea that there was structural error here. To be clear, McCaskill stood for the idea that the denial of the right to represent oneself is not reviewed for harmlessness, because as the court in McCaskill put it, there's almost always going to be harmless. Counsel is almost always better than pro se. And so to continue to have teeth in Ferretta, to make sure it's respected, we must treat it structurally. That logic does not apply to the inverse, though, where a defendant unequivocally stated, I wish to proceed representing myself, and the trial court accepted it. So McCaskill doesn't dictate here. Gideon also in its progeny, when we're talking about the total deprivation of counsel, also does not apply because he wasn't totally deprived. He did spend a couple hours representing himself, but that's not the heightened level of total deprivation that the Supreme Court has said is necessary in order to create this structural error. Without structural error, we turn back to 1443, subsection B, where it's harmless beyond a reasonable doubt. And for largely the same reasons as outlined in the statutory discussion and as outlined in the state's brief, any potential error here was harmless beyond a reasonable doubt. Should we even say the Sixth Amendment issue is not only preserved properly within the PDR and there was error, it's still not prejudicial.
Can I ask you about the state's position on State v. Gentry? Are you saying that Court of Appeals opinion was wrongly decided, or should we follow that in this case?
I think State v. Gentry does a great job of recognizing that there's a world of technical violations that don't have any meaningful impact upon the range of permissible punishments. I think that certainly this court can and should give it its stamp of approval to say that it is not error in these kind of unique issues where there is a life sentence, and so life is life. It doesn't really matter if we dig down past that. But I think this court can go a step further and recognize this prejudice analysis. This is a statute like any other statute. As this court recently recognized in Hamer, even statutes that implicate a constitutional right, such as in Hamer, the right to waive a jury trial, that still is reviewed for harmlessness. And just as in Hamer, it is as well here, there was no prejudice. Unless your honors have any further questions, I respectfully ask that this court affirm the judgment below.
Thank you, counsel. Rebuttal.
I'd like to point this court to its previous decision in State v. Hucks, where this court held that the violation of the statute that required the trial court to appoint 2 attorneys for each capital defendant, that wasn't complied with in that statute, and this court held that error was error per se. It explicitly refused the state's request to apply harmless error analysis for reasons that I think are applicable here. It would require peering into an alternative universe of knowing what might have happened had the statute been complied with. We can't know. Any measurement that this court said in Hucks, any attempt to measure that prejudice would be unreliable. I think that analysis, that logic applies here. The state wants to read statute, section 1242 out of the general statutes. The trial court can make a 146-year mistake, and that's okay. And Mr. Macon has to show prejudice, even though he would almost never be able to, because we can't peer into the alternative universe and know what would have happened if he had been correctly informed of his sentence. Having a statute designed to protect a constitutional right that provides less protection than the constitutional right itself, that's not a statute. Why would any competent attorney moving forward raise an argument for a violation of 1242? If the trial court can be wrong by 146 years and a defendant can never show prejudice. The other point I want to mention is there are Supreme Court cases that list structural error, and several of them do not require that the deprivation of counsel be complete. They just say the denial or the violation of the right. And I think the cases that do mention the complete denial, I read those cases as distinguishing them from ineffective assistance of counsel claims, right? Where there was counsel provided, but their assistance was ineffective, deficient. I think that's what the Supreme Court meant when it was talking about a complete or total denial. And in Weaver, the Supreme Court was clear. It's a violation. It's a violation of the right to counsel, not a deprivation. It described it as a violation, not a deprivation. Structural error can still apply, even if it's just a violation rather than a deprivation. Thank you.
Thank you, counsel. Thank you both. Mr. Clerk.